outside of like regular politics and elections and stuff. I'm trying to avoid it.
I'm just the same. It's had bad experience.
Thank you. Okay. Good afternoon. Let me call the room to order, please.
It's a temptation.
Please grab a seat. I'm a little biased, but I think it's been an excellent day of debate and discussion. I'd like to thank all of our presenters for their participation today. Please give them all a round of applause. It's my honor this afternoon to introduce our keynote speaker, the U.S. Department of Justice's Assistant Attorney General for Civil Rights, the Honorable Harmeet Dhillon. We are delighted. We are delighted that she could be here and make the time during such a busy day. Harmeet is a nationally recognized civil rights and constitutional law attorney and a great friend to the society. If you've ever had the pleasure of meeting her, it's immediately clear how principled and smart she is. She graduated high school at 16 and entered Dartmouth College. After Dartmouth, she received her law degree from the University of Virginia. From there, she clerked and worked at several law firms, moving from a focus in intellectual property, I believe, to civil rights. In 2006, she founded the Dhillon Law Group in San Francisco. The successful firm now has 25 attorneys and is known for its expertise in the areas of civil liberties, free speech, business, and political law. Last year, I recall being rather blown away by her appearance on the Tucker Carlson podcast in October. If you didn't catch it, it was a meticulous tour de force of facts and evidence about the political background of former Vice President Harris. The episode was 2 hours long, and Harmeet demonstrates what a detailed and overwhelming advocate she can be. Afterward, I complimented her on the presentation, and she immediately exclaimed that the show was much too short and that she had hours and hours more of research and material that she never got to bring up. She has a great political mind. She's a lawyer's lawyer and is a fierce advocate. Please join me in welcoming Harmeet.
Thank you so much, Nathan, for that tremendous introduction, and it's a real pleasure to be here today with all of you. I see a lot of friends in the audience. One of my former law partners who took my place on the free speech and election law section is here as well, and my special assistant who gets me from place to place here came from the Federalist Society, Deborah Cumby. I think many of you know her, so I want to recognize her for helping me prepare these remarks and coming here today. So I had a little bit of a challenge. I have so many thoughts about the first 5 weeks here at the Civil Rights Division, so bear with me as I jump from topic to topic. But I've been a member of the Federalist Society for 35 years, believe it or not, and started in my first year at UVA Law School and eventually became the president of the largest chapter in the country. So it really means a lot to me to be the keynote speaker here today. Many of you may not know this, but this current stint that I have at the Department of Justice is not my first tour of duty at the DOJ. I was really interested in constitutional law in law school, and I got a call from the head of the Constitutional Tort Section in the Civil Division my second summer, also known colloquially as Bivens. And so I was invited to be the sole law clerk in the Bivens section at DOJ, and I was so excited because I was like, finally, I went to law school to do constitutional law, and now I get to do it. And any of you who've done Bivens work know what a disillusioning experience that would be for any lover of the Constitution to find out that indeed our government, federal government, sometimes burst into the wrong home or arrest people while they're doing a protected First Amendment activity, and then DOJ lawyers, there were 27 of them at the time, have to defend that, and of course now the Supreme Court has cut back Bivens to the point where I don't think there's a Bivens section at DOJ anymore, and that's okay because I'm getting the chance to do the other side of that, and I really love it. So Eventually, this focus on civil rights I made into my whole career, and it has been among the most rewarding parts of my life. And so when President Trump, Pam Bondi, and Elon Musk cold called me one day in November after the election from Mar-a-Lago, it was an unrecognized number, but it was, I know people in Florida, so I picked it up, and Pam was like, hi, I'm here with Elon and the boss, and, we'd like to talk to you about DOJ. So, of course, I accepted this tremendous opportunity. It was a dream come true. And in this less than 6 weeks since I've been confirmed, it's been everything I thought it would be and a few more things that I didn't think it would be. And so if I have time at the end, I'm happy to answer some questions that you might have about some of the details. In reflecting on the beginning of our nation's great history, John Adams wrote, "The revolution was effected before the war commenced. The revolution was in the minds and hearts of the people. This radical change in the principles, opinions, sentiments, and affections of the people was the real American Revolution." Under President Trump's leadership, we have a generational opportunity for a reformation within civil rights, one that reflects the will of all the American people. The usual approach under Republican administrations, many of you will be familiar with this, has been towards what some would call the color revolution wing of the DOJ, has been to sort of just try to slow things down. Let's call it 10 out of 10 in one direction. Let's see if we can slow it down and make it 6 out of 10, 7 out of 10. Just slow the train down. There really hasn't been a focus on turning the train around and driving it in the opposite direction. And that's my vision of the DOJ civil rights. One where we're the plaintiff's firm for the American people when it comes to civil rights. Where we affirmatively use the lawyers at civil rights to frame cases under our statutory mandates. We have 11 different sections in civil rights. Where we advance the goals that we the people voted for. One where we attack unlawful racial quotas and mandates, where we sue the government entities that violate and abridge our religious liberties, where we enforce women's rights of privacy in their spaces, and the Title IX promise of access to education and sports opportunities, where we look at compliance under NVRA and HAVA and the Voting Rights Act, where we protect the Jewish students who today at Columbia University, as we speak, are in the middle of a mob scene in their library being attacked while they're trying to simply get an education and graduate. We don't just slow down the woke, we take up the cause to achieve the executive branch's goals. This is the opportunity where we can ensure that our nation's civil rights laws benefit all Americans, not just a select few. The theme of this conference is theories of presidential power. I want to focus on two central ideas. First, we need a strong and consistent civil rights enforcement regime from the government. Second, we need people, committed, courageous people, that is lawyers and paraprofessionals willing to do the work to make this vision a reality. My views on some of these issues, frankly, have changed over time. I was a child of the Reagan Revolution. My first campaign was to work for Jack Kemp for president in 1988. I worked at the Heritage Foundation in the late 80s. In those years, a central tenet of the movement was that we need to get out of the way and let the private sector do its thing. The market, free and unfettered, would self-correct its imperfections. Well, let's review how that market has delivered civil rights as we understand it today. The persistent cry of deregulation has gotten us pervasive illegal entrenchment of DEI in our states, our universities, and our workplaces. Missed opportunities for girls and women to achieve titles, awards, and scholarships in their sports, free from male competition. Political indoctrination of transgenderism and gender ideology in children's schools without parental consent. Clear abuse of the FACE Act to target the peaceful speech and prayers of people of faith. Myriad unenforced federal election laws preventing American citizens from believing that their elections are free and fair. These are missed opportunities and worse. The tone for this entire administration starts at the top, and under our president, we are going to change from a laissez-faire, you-know-best approach to an administration that takes its statutory obligations to enforce the civil rights laws equally and non-discrimination laws seriously. This paradigm shift is both necessary and overdue. Let's get to the part no one's going to tell you about, what it's actually looked like in the first 4 weeks of my job, or what no one's going to tell you about honestly because it's being described in the mainstream media as a bloodbath. My perspective is a little different. I have the privilege to work with a number of amazing, dedicated people who are doing a fantastic job of working and focusing on the president's agenda. Several of them are career professionals, not just the political people who have come along with me. But there were hundreds of people working in the DOJ Civil Rights Division that had some different ideas about our agenda. For example, to enforce the president's executive order on anti-Semitism, we put out a call to all the lawyers in the Civil Rights Division asking for volunteers to work on that task force then being led by my friend Leo Terrell before I was confirmed. Anyone want to take a guess on how many attorneys raised their hand to help with the anti-Semitism task force project? There were 3 of them out of 400. That set the tone as to what I could expect on what should clearly be a bipartisan, non-controversial issue. Hundreds of lawyers in the DOJ simply decided that they weren't going to raise their hands and help with that. In the second week on the job, after all the HR training and the SCIF training and the benefits and finding my way around the hallways and the shortcut through the library that many of you may know about, I laid out my priorities for the lawyers who work in the Civil Rights Division. Priorities like investigating federal funds to schools that may not be compliant with Students for Fair Admissions, dedicating resources to protecting Jewish Americans from pro-Hamas vandalism and intimidation, refocusing our attention on fact-based cases of police misconduct, not statistical claims that verge on junk science and wouldn't pass the Daubert test, and the like. As lawyers, we started from a statutory and constitutional basis. Now, I would have loved for all the lawyers in civil rights and the paraprofessionals to roll up their sleeves and get to work with me, which is what happens in every administration, enforcing the directives that the administration has outlined. But a lot of lawyers didn't want to do that. And when you look at the recent record of the division, it may be clear why. Under Biden, the Civil Rights Division sued Georgia for improving its voter laws, claiming that these common sense proposals would, and I quote, push more black voters to in-person voting, where they would be more likely than white voters to confront long lines. That's it. This fact-free hypothesis was characterized as race-based discrimination under the Voting Rights Act. Under Biden and prior administrations, decades-old police and educational consent decrees were not only sloppily and inconsistently enforced, but they remained open for decades. Decades past the time that every human being involved in those fact patterns had either died or retired. This last week, we dismissed a 50-year-old plus Louisiana consent decree at the request of all parties that in a case where the schools had desegregated 2 generations ago, but nobody bothered in the Civil Rights Division to do an audit and close the books. And there are many, many more cases like that we're uncovering as we go through an audit. So yes, it was a shock to the system to hear that we expect the lawyers in the government, part of the executive branch, to enforce the new administration's priorities under the rubric of the statutes that we enforce. It catalyzed over 200 attorneys to take what we call the fork in the road, and that tens of thousands of other federal workers have taken. We wish them well in their future endeavors and their passions. They need to pursue them elsewhere. They're not going to be happening at the DOJ. Before the president was inaugurated, the Biden administration, for its entire 4 years, resisted the unionization of lawyers in the Civil Rights Division and in the Environmental Division. You may have read in the press that these lawyers decided to unionize. Well, when did that happen? It happened after the election, and the administration suddenly decided to change its position 180 degrees on unionization and stopped opposing the unionization. So that matter is currently in federal court now, so I won't say more than that, more about it than that, but that gives you a tone of what we're dealing with in this new administration. There is a real opportunity here in the Civil Rights Division to do good for our country. And we have a whole of government approach that we're pursuing at the DOJ. And on a daily basis, I'm having calls with lawyers in the White House. I'm having calls with lawyers at HHS, Department of Education, and the GSA, just on the DEI and educational discrimination issues alone. And there are many other collaborative conversations happening. I've formed a great relationship with Andrea Lucas at the EEOC, and on a daily basis, I meet more and more of my colleagues in the executive branch, and we are all working together and rowing in the same direction. And it is a very exciting time to be a lawyer at the DOJ. Our affirmative approach in civil rights has just begun, but I'll give you a few examples. It includes investigating unlawful DEI scholarship programs, resulting in merely the opening of the investigation, resulting in the shutdown of a minority-only program in Illinois. We have over 70 open investigations into admissions at schools to ensure compliance with Students for Fair Admissions. 70 letters that I signed. We're beginning to get volumes of information back, and a few schools that are actually doing the right thing. It's great to hear from the schools that are learning from mistakes of the past, and we'll be highlighting those success stories as we go along. It's not all bad news. So far, we filed statements of interest into zoning regulations that have unfairly restricted both Christian churches and Muslim mosques in different jurisdictions from assembling, and into an airline travel program that would deny applicants on the basis of race. I have a torrent of RLUIPA zoning issues on my desk that my team is analyzing involving different places of worship. We've withdrawn numerous division statements that would seek to force states to provide unnecessary cosmetic surgery to cater to inmates' claims of gender dysphoria. We're combating anti-Semitism as the top of our list in the Civil Rights Division at this time. We've already enacted our anti-Semitism task force. Earlier today, I met with Orthodox of the Union of Orthodox Jewish people with a lot of different input from different communities within the Orthodox community. And we've had ongoing conversations with rabbis throughout the United States about discrimination that they're facing throughout the country. We're enforcing equal protection under Title IV for Jewish students facing anti-Semitism at their college and K through 12 public schools, and we're meeting with faith leaders. It isn't all bad. We're hearing a lot of good things. I am perhaps notorious early in my career for being the editor-in-chief of the Dartmouth Review when we sued Dartmouth for kicking 3 of my colleagues out of school, suspending them indefinitely for their speech. And we sued. We had this wacky ACLU lawyer fly in from New York. He insisted on a private plane. He wore a fur coat. He's a very colorful character. And this baller rolled into Hanover, New Hampshire, and sued Dartmouth, and we won. And those 3 students were reinstated, and that really changed the course of my career. But it kind of permanently left me with whenever I got those solicitations from Dartmouth asking me to contribute. They didn't get a big check. I had a wonderful meeting last week on Monday with the current president of Dartmouth College, Sean Belloc. Sean is doing it right. Dartmouth acted quickly when shanties obstructed the green. They tore them down. They arrested the students who ignored warnings that they were not to be interfering with other students' ability to get an education. And so I was really heartened to hear that. And she invited me to come speak at Dartmouth, and I may go do that in the fall. So aside from a strong and consistent civil rights enforcement, the other part is also very important. We need the people willing to make it happen. Now, I'm going to have some frank talk here. We're at a fork in a road in the conservative movement. Many law students and lawyers have sought the obvious career path. I mean, that's a good one. Prestigious Supreme Court or appellate clerkship, make partner at a big law firm because it's a risk-averse path, make a lot of money, have the second home. I mean, I've gone down that path myself. I have a second home, so I'm not going to shame anybody who does, okay? But it's clearly charted from the outset in our top law schools, and it's structured. 2L summer internship, maybe you do a gap year, a clerkship, a second clerkship, maybe you do a third clerkship. You go back to a firm, you get a bonus, a big bonus. You make partner, and it's a pretty safe career path. This long-standing career wisdom, which has essentially displayed itself as a tacit alignment with the defense bar, let's be honest, has in some ways really stifled the conservative movement's ability to do the work needed to defend the rights of the most vulnerable in our nation, both in public service and in the private sector. When I came out of law school with my dream to do a career in civil rights, there was no law firm that would hire me to do that. I could not make a living doing that. So yes, I went to big law, I did that, I did 10 years of that, I worked in New York, London, Silicon Valley, San Francisco, and eventually I was able to start my own practice, and now I have people coming out of law school who want to do that as a career, and I'm excited about that, but that's a little corner of the universe. We need a volume of lawyers who are willing as a career to be dedicated to the principles that our founders started this country on, and they're important principles. I believe in them. I testified during my confirmation hearing that I believe in the civil rights laws of this country, and I intend to use them for the good of all American people. To build a government that actually enforces rather than neglects its citizens' civil rights selectively, we need people in roles who know how to do that work, who know how to bring cases as plaintiffs' lawyers, find facts, navigate statutes, think creatively, win at trial, not just litigate behind a desk or reach a settlement. Right now, we have a twofold problem. The people who may know how to do this are not aligned with certain presidential administration's priorities, like this one. And those who may be willing to step into public service roles may not have the necessary experience to thrive and succeed on behalf of the United States and on behalf of the American people in this extremely important role of protecting vulnerable Americans harmed by discrimination, instead of protecting the businesses for $2,000 an hour who do the discrimination. We also arrived here because we needed conservative lawyers, plaintiff-side lawyers, to find and protect the rights of ordinary American citizens from private power. Mostly we don't deal with private power in the Civil Rights Division, but there are instances where we do. While it can be daunting, I'm here to tell you from both my experience in private practice in over 3 decades and now serving the public, that the risk is absolutely worth the reward. Not only the reward of seeing cases successfully won for deserving parties, but the reward of choosing cases that you care about, where your values are not compromised in what you do for a living. We know that civil rights enforcement can't depend on who's in power. It must be strong, it must be consistent, and it must be built into our legal system and into our legal culture. The good news is that the work is now being done. We have a president who has issued many executive orders that will restore balance to our important civil rights and our statutes. There are advocates who are investigating the facts and filing the lawsuits. I have more applicants than I can possibly hire right now in our time in the government as we're in this Doge phase of our process. I never thought I would see the day, but it's a thrilling time to be a plaintiff's lawyer in the biggest law firm in America, the Department of Justice, and we're just getting started. Thank you. I'm happy to take questions.
Okay, Harmeet has graciously agreed to take questions. Would anyone like to ask a question at the microphone? Please announce your name and affiliation and ensure that whatever you state ends in a question mark and is somewhat succinct.
Yeah, hi, Paul Kamenar, an attorney here, and Harmeet, congratulations. You're doing terrific work at the Justice Department there, cleaning house of all the attorneys who not share your vision and President Trump's vision. Could you just give us an update on that litigation with Maine regarding withholding the funds because of the Title IX violation of the transgender athletes? I understand there was a settlement we reached between USDA funding, but there are other ones with the Department of Education. I'm not clear where everything stands in that case.
Well, that case is ongoing, and so there are aspects of it that will continue. The DOJ filed a lawsuit. There's lawsuits going in both directions. Some of these cases where some states, Minnesota, has acted preemptively to sue when we're just in the beginning of an investigation phase. So typically we are the government. We move deliberately, and we also have some policies at DOJ that when you're attacking a state, you have to follow certain processes. So it isn't like being a plaintiff's lawyer in our private practice, where you could just see some horrible thing on Friday and go for the jugular on Monday. So that's a little bit of one of the limitations of the government. But these things are working their way through. There are conversations happening. I will tell you, in the educational space, some of those 70 schools that got letters from me are, it's like President Trump with the tariffs. They're asking for meetings. They're coming to the table to preemptively negotiate a settlement. So it's a free flow of deal making happening in civil rights. Yeah.
Thank you.
Very good. The near mic here, sir.
Yeah, I'm Dick Black, former senator of Virginia, and I was the supervisor of Mac Warner, one of your subordinates.
My principal deputy.
I was really pleased and excited by President Trump's executive order against disparate impact. The idea that you look at statistics and which group gets favored more or less, that seems very far-reaching, and I'm just curious, is that going to be something that you can use as a tool to begin to pull back on some of the lawsuits that have already been filed, or some of the consent orders that are in place?
Well, I can't really talk about stuff we haven't done as yet, but I will tell you that the executive order on its face does require the Civil Rights Division to actually, go through and do that, and other parts of the government as well. I mean, and those of you who are familiar and do employment law will be aware that for a very long time, the EEOC has really only brought statistical cases, Duke Power type cases. And so that's going to be a sea change over there as well, something I've discussed with Andrea. But it is not just the employment context, which is where it is commonly thought. I gave you the example of police consent decrees or consent decrees that were about to be signed or submitted to a court. We have found that many of them are based on tiny statistical differentials that, in my opinion, as a trial lawyer, would not really meet the smell test. But for decades, a lot of the power of the federal government is so overwhelming. Anyone who's in criminal practice will know that the power is so overwhelming that things that should be litigated and challenged on the other side are not, because the stakes are too high. A cautious corporation or state is not going to roll the dice because the DOJ might double down and hit you with 19 other things, and other agencies might as well. So these I will call, frankly, flimsy statistical cases have not been litigated. DOJ shows up and says, hi, I'm DOJ, I have 400 lawyers, and we're going to put you in the penalty box, and you need to agree to these terms. And the other unspoken aspect of this is that there are, probably going to offend some people in this room, but there are law firms getting rich on monitoring flimsy consent decrees. And that's one reason why they never end. And some of our friends are doing it. Some of the people in the room may be doing it. Sorry, you will not be doing it for much longer, because at civil rights, we are not doing that business anymore. And so we are in the business of, when people have corrected their prior wrongs, getting out of that situation and terminating it. But yes, disparate impact analysis does permeate many aspects of our government, and I think the president's call to dial it back is overdue, and we are certainly working with all diligence to effectuate it in civil rights.
Thank you.
This gentleman, please.
Thank you very much. I'm Brecken Thies with the Federalist, and you mentioned DEI in your talk at universities, and we both went to University of Virginia, so I want to use that as an example, but this is a broader issue as well. So the Board of Visitors, you might know, decided to get rid of DEI and basically tell the administration that it's going to be gone. And the administration at UVA essentially decided to, delete some references to it, take down some websites, but in reality, they're just kind of removing and replacing people and embedding them, kind of anonymously into the administration to continue their work, essentially. So my question is, what is the Department of Justice able to do to ensure that DEI is actually eradicated from an institution as opposed to just hidden away?
Well, there's two things. First of all, we use the term DEI as sort of a shorthand for a collection of principles and practices that are now, in my opinion, illegal, should have been illegal, and are illegal under the civil rights laws, but the Supreme Court told us they're illegal. So, we're drilling down on that and really kind of defining that in some of the documents that the government prepares. But I was very disappointed to see that. I went to law school with Jim Ryan at UVA. He was a year ahead of me at UVA. I think he was Ken Paxton's classmate, if I recall correctly, as well. So a lot of people there at the same time. But they're just ignoring what their Board of Visitors is saying, from what I can tell. It's a problem. They received 2 letters from me, and we are in an investigation of whether UVA is doing the right thing. There was an incident last year of a Jewish student who was not protected when a violent student attacked them, and that student's on campus. So not taking it seriously. So these are very concerning issues, and might not be getting a little. UVA used to get a check from me every year when they made their solicitation, and I might not be getting that either. So.
Thank you for your question, Larry.
Yeah, 2 things. One, to the desperate impact. One thing you guys might want to do, for example, is Section 605 of the Infrastructure Act, where the Republicans got rolled. Income is a protected class. We've done the only peer-reviewed paper on disparate. I mean, it just doesn't make up, but it is an ongoing thing. So good for that. But going back to your topic, although I'm not authorized on behalf of my people, I'd like to thank you and the administration. Prior to you guys coming in, rather than look at civil rights law, we had to look at Second Amendment law. So my question for you is as follows. I'm serious about that. And I live in Maryland. I have to get a DC license. It's not pleasant, which is what the judge was talking about today at lunch. The judge who was speared. He's the guy who made the video about Second Amendment. Anyways.
Judge Van Dyke.
Thank you. But my question for you is this. I was watching a panel the other day, I won't say the name of the organization, and they were talking about the Columbia case, and I know this is a big deal, but like even today, Twitter is ablaze with pictures of them, of radicals taking over the library. What is the theory of the case that you're trying to do here? Because apparently, I've heard people on the other side that, you know, these are just, it's like the old Mel Brooks lines, oh, what, they're just going to camp. I mean, just, they're harmful, peaceful, mostly peaceful protests. What is the theory that you have? Because I admire the effort, but I'm just trying to figure out what can be done, because it doesn't seem that anything is still being done to get, I mean, it's a fine line over peaceful protests, but I mean, GW's campus this last summer was horrific. What do you do? Because it's very, very real and very, very scary.
Well, so you raise a number of complex issues. So first of all, with respect to Columbia, I and a couple of other lawyers here in this room are in daily negotiations there, so I can't really talk about that, but I will tell you that I had some text messages from coming into this speech, and I think you'll find when we walk out of this speech, Columbia may have done something about that library situation that is not the usual surrender monkey behavior. So I think that's refreshing. I think there are many people there, many constituents that are very serious about righting the wrongs I mean, they put out a March 21st or something statement, and they've made some commitments publicly already without a settlement with the government. And so what you can do is treat these crimes like crimes. They're crimes. It is a crime when a student is punched, a student is obstructed, a student is stabbed, a synagogue is attacked, people block access to a synagogue or a Hillel or Chabad facility. These are illegal acts, and you know, and the Civil Rights Division has a criminal wing. Again, when we walk out of here today, you may see you know, a prosecution that has been announced that is occurring in a major American city. So this stuff is happening all now. So you have to give us a chance to do that. We don't have U.S. attorneys confirmed yet. I've had many conversations with several U.S. attorneys. My good friend, who's the acting in Los Angeles, and I have Bill Lasaley. We have regular conversations about working together for what's happening on the UCLA campus. The prior administration treated it like a joke, and it's not a joke. It can cause lifelong scars on these students to be othered, if you will, to use the term of the left. So we're taking it very seriously, and I think you're seeing that.
Well, thank you.
Forget one more? Or?
Yeah, sure.
Please.
Hi, I'm Kalen Dees with the Washington Examiner, and kind of piggybacking off of what my colleague Brecken just said a moment ago about all of the ways that DEI offices are being sort of disguised rather than, you know, eliminated. I'm wondering, you know, sort of in line with what this administration has been attempting to do with transparency and letting people know about the actions that are being taken, such as the website set up for Doge. Does your division have any plans or things to try to keep people up to date about what is happening on the ground to try to enforce, to make sure that these illegal DEI programs are not just being tucked back into like a separate office or things like that? Like, are there any plans to try to be more transparent? For example, you know, the group Do No Harm has a database of a bunch of universities and institutions that still are engaging in these DEI practices. So I'm curious if you're keeping tabs on this and trying to, you know, keep the public informed about where these, you know, problems are still persisting.
Well, thank you for the question. So first of all, as a plaintiff's lawyer, I love whistleblowers, and we do rely on whistleblowers to tell us these things, because there's only so many lawyers. I'm down by 50%, which will hopefully get fixed, but we need members of the public to tell us what's happening. We have a hotline, different hotlines on the DOJ website. People email me. I've literally in my career of 32 years, I've probably got thousands of lawyers, and they're all texting me. So I'm hearing from my friends, and there are quite a few excellent lawyers who are members of this organization who are bringing compelling private suits. A Civil Rights Division doesn't have jurisdiction over everything, okay? But we have jurisdiction over some things, and other things we can file a statement of interest. We can move to intervene. If we don't have original jurisdiction, we can add a claim to a case. But plaintiffs' lawyers, those private plaintiffs' lawyers that I said we don't have enough of, they're doing the hard work of doing the fact-finding and bringing the evidence. And you know, there are innumerable key TAM cases that could make people rich if they just did the work and connected the dots. Different recipients of billions and billions of dollars of federal grants are routinely lying on their grant certifications, on their applications. They're lying, and they're defrauding the American taxpayer. And the lawyers and their clients who identify that fraud are doing a public service by doing it, and they're rewarded for that. So we absolutely are not the replacement of the private sector in this work. We are the partner of the private sector. But we want to hear those cases. The other thing I want to say is, as again, a longtime civil rights lawyer, you learn about impact litigation. I cannot bring a case on every case that I could bring because they're just inefficient. What I can do is sift through the cases and bring the best cases. It's among the analyses that we engage in at civil rights, like any good lawyer, is, well, the worst things are happening in my home state of California, but is that a good place to bring a lawsuit? How's the Ninth Circuit going to rule? You might as well set your life back 2 or 3 years by filing it there if you could file it in another circuit. So we are being selective, and so we're winnowing those cases, bringing them in, and smart plaintiffs lawyers who have joined me in the leadership of the Civil Rights Division are doing that analysis, picking and choosing our jurisdictions and where we have the best facts and test cases. And so, rest assured that it is whack-a-mole every day. I was joking with one of my colleagues. He came into my office. I'm like, dude, what fresh hell is this? It's always some crazy new thing but it's fun, actually. We're really having a great time. And I just wish I had more hours in the day to do it. Thank you.
Well, thank you very much, Harmeet. We really appreciate it. Thank you all for your attendance today. The reception is starting across the hall, and I don't know if Harmeet's schedule permits, but she may join us or she may have to go to business, but we really appreciate all your remarks. We appreciate your service. We look forward to having you again sometime soon down the road. Thank you. Thank you all.